Lawyers all over New York State come to Block, O'Toole and Murphy to try their more significant cases. I want to talk to you today about the importance at trial of direct examination and cross-examination. Witness testimony is one of the cornerstones of trial practice, but far too often, direct examination, the witness that's called by a party and then the questions that follow, is ignored in the hierarchy of importance for trial lawyers. Direct examination is the foundation in which you are able to persuade a jury during your summation about why your verdict, the verdict that you're looking for them to return, is just. In direct examination, you call a witness to the stand and you ask questions. Those questions are by law supposed to be open-ended questions. It's not a yes or no question. Instead, it's, why don't you describe for us what you saw? And then you let the witness go. When a witness testifies on direct examination, one of the things that's important is eye contact. Now, you don't really care if the witness makes eye contact with you. You instead want them to make eye contact with, typically, your jurors. So sometimes where a lawyer stands can be important in that respect. If the lawyer stands in a position where they're over here and the jury's over here, it's hard for the witness to look at that lawyer while the lawyer's asking the questions and then make eye contact with the jury. You find it looks like your witness is watching a tennis match, following the ball go back and forth. Instead, the lawyer positions himself or herself strategically in an area where, when the lawyer is asking the question, the witness, while looking at the lawyer, is also making eye contact with the jury. It builds trust. It allows the jury to kind of evaluate the witness in a non-invasive way. Everyone's looking at the witness because the witness is looking at the lawyer. Direct examination is an opportunity for the lawyer to take a step back and let a witness tell the story. You want that witness, contrary to other parts of a trial, to be the star in that moment. The lawyer should never try to be the star during a direct examination. A lawyer needs to ask questions that gives this witness a forum to tell their story. A lawyer should be meticulous about structuring and layering the questions that they're going to ask so that there is a common sense approach to the order of the questions. Remember, it's got to be received by the jury, digested by the jury, so that they're understanding the points that you're trying to make. And doing it in a chronological order is typically the best way to do things. Organization is key. Now, preparing a direct examination doesn't just mean that you're going to conceive of the questions that you're going to ask before. You have to go through these questions with your witness. You go through the questions that a witness should anticipate on your direct examination. You also prepare them for the questions that they may get asked on cross-examination. Sometimes you'll have a witness who has a checkered history. I would say to anyone that's watching this, it's important as a person who's preparing a witness and going through their background to let the witness know you should anticipate being asked about this and prepare them. You should also consider whether, as a strategy perspective point, does it make sense for you to ask the witness, even though it's your witness, about their checkered history? Get it out there so it doesn't look like you or your witness have anything to hide. Now, any lawyer that concludes their direct examination, when they sit down, they have to be listening carefully during cross-examination in case their adversary asks questions that are objectionable. And if they are objectionable, then you're going to stand up and raise that objection to the court. When a direct examination is over, it's time for cross-examination. A cross-examination is when your adversary calls a witness. They ask that witness questions, and then they're done with their questions, and now it's your turn to examine that witness. When you're conducting a cross-examination, as opposed to a direct examination where you would ask open-ended questions, a cross-examination is typically where a lawyer asks leading questions. Now, what's a leading question? It's usually a question that requires a yes or no answer or a one-word answer. One of the main tenets of cross-examination is you want to be able to adversely affect the credibility of the witness that was called during direct examination. Cross-examination is about controlling the witness, being in control of the courtroom. You are the show. The jury's eyes should be on the lawyer and then the witness. Now, many times, because people watch TV, they think that cross-examination, it has to result in a take the witness's head off to be successful. And I'm here to tell you that that's just not true. A good lawyer, an effective lawyer who's got experience in cross-examining witnesses during trial will usually come in and say that they have 2 or 3 objectives. The Perry Mason moment where someone says, "Aha, you got me, I lied," happens once in your career, if that. Really what you want to do is you say, I have 3 points that I think I can get out of this witness. And you ask short questions that lead up to a particular moment where you're able to make your point. When you don't have anything to ask a witness, when the witness isn't hurting your case, sometimes the most effective move is to say, I have no questions. You're not wasting the jury's time, and in essence, you're sending a subtle message to that jury. That witness didn't lay a glove on us. Didn't affect us at all. When you're thinking about the structure of your direct or your cross-examination, what you're really doing is you're trying to build an argument that you're going to employ during summation. And whether there's a certain witness who you can rely on because there's independent areas that can corroborate what that witness has to say, well, that's important to build for your summation. Or it could be, you can't trust this low-life skell. Look at who this person is. You need to know who they are before you evaluate what they say. Those areas, they're not just for that moment, but they're for you to utilize as a lawyer effectively during your summation. You're giving the jury tools to deliver the verdict that you're seeking.